Hi, my name's Ollie, and in this Politics Explained video, I'm going to go through everything you need to know about rights in context in A-level politics. So the idea is to give you everything you need to know, so that's not just all the knowledge and examples you need, but also kind of key points of analysis, potential questions, so that you can be fully prepared for the exam. So in terms of this video, I'm going to start by going through the kind of key questions you could be asked in relation to rights in context, which is part of the democracy and participation part of UK politics. I'm then going to kind of go into an introduction to rights in the UK, some key milestones in the development of rights, as well as some key debates in relation to the Human Rights Act. From there, I'm going to go into civil liberties pressure groups, which is a key part of the specification, look at 4 examples and how you could use those in essays. And then finally, I'm going to look at how the judiciary and Parliament and the government defend rights in the UK before summing back by kind of going back to some key debates over rights. So that's collective versus individual rights and overall debates about how well rights are protected in the UK. So if you want to access the PDF that you'll probably be seeing up there, go to the first link in the description to the Politics Explained website where you can download it. And yeah, on the Politics Explained website, there's loads of other content that can help you in your politics A-level, including essay plans, which will include a essay plan on rights, and which I'll kind of very soon be improving and updating, and as well as a place to sign up for tutoring if that's something you're interested in. So yeah, without further ado, let's get into it. So in terms of the parts of the specification this lesson covers, it's UK politics and it's the first topic, so democracy and participation, and it's the kind of 4th part of that. So it's rights in context. It kind of covers major milestones in the development of rights, and then key debates on the limit, extent, and tensions within the UK's rights-based culture, including kind of individual and collective rights, conflicting, and civil liberties pressure groups. In terms of the kind of potential essay questions you could be asked in an exam, there's kind of 2 key types of ones which are really good to plan essay plans for before the exam. So the first one is just an overall question on how well rights are protected in the UK, which at the end of the video I'll kind of go into how you could possibly structure this. And the other one you could get asked about that hasn't been asked yet is kind of comparing different parts of the UK political system and how well they compare rights, how well they protect rights and how they compare. So that's kind of civil liberties pressure groups against the judiciary, against Parliament and the government, against legislation potentially. So if you prepare kind of 2 key essay plans for those, you should be in pretty good stead for the exam and then be able to adapt them to any more specific questions. As I mentioned in the kind of bank of UK politics essay plans, I'm going to include those 2 essay plans if you want to purchase them. They won't yet be ready on the Politics Explained website when this video goes out, but they will do before the exam this year. So, starting off with an introduction to rights in the UK. Firstly, what are rights? So, rights are legally protected freedoms and they're also known as civil liberties. They're absolute, universal, and fundamental. So that means they can't be compromised, everybody has them, and they can't be removed. In the UK, they're kind of traditionally unwritten, and as I'll kind of go into later, they were negative rights. But since the 1998 Human Rights Act, they've been brought onto the statute book and are now kind of positive rights and entitlements. It's still kind of broadly accepted that rights may have to be limited in times of war or other national emergencies. So, for example, during COVID, lockdowns were a real limit on the freedom of movement, which is a kind of, the right to freedom of movement, which is a really key human right. But it was nonetheless kind of broadly accepted across the political spectrum and among the population. So, what do rights in the UK include? So, there's quite a few of them, I just included a few here. Fair and equal treatment under the law, freedom of expression, conscience, the right to vote, the right to belong to an association such as a trade union, also political parties, freedom of movement, and there's also more contentious social rights, such as the right to education, employment, healthcare, and welfare support. So, of course, for example, the right to healthcare in the UK, you have the NHS, which is free at the point of use. That's not necessarily the same in a lot of other countries. So, in other countries, they might not have the right to healthcare, and it's a bit contentious, the idea of the right to healthcare in the UK. But the key ones are just the kind of freedom of expression, freedom of speech, right to protest, etc. Kind of as a kind of complementing rights, you have civil responsibilities and obligations. So these are kind of also in two different camps. You've got legal obligations such as obeying the law, paying taxes, and performing jury service, which you have to do. Otherwise, you'll kind of get punished by the state. And they're seen as complementary to rights. You also have things which aren't kind of a requirement for being a citizen, which are moral responsibilities, such as voting in elections and playing a part in protecting the environment. Don't necessarily have to do those, but they're seen as moral responsibilities. So, in terms of before the Human Rights Act, there was no single document setting out rights in the UK. Instead, there were negative rights, as I kind of mentioned before. So, pretty much it was you had the right to do something if it wasn't prohibited in the law. So, for example, in relation to speech, you had freedom of speech as long as you weren't committing libel or blasphemy. And some rights were protected by Acts of Parliament, whilst others derived from custom or common law. So it's much more negative rights, really how rights were protected in the UK. Since the Human Rights Act, though, it now has positive rights, with that Human Rights Act setting out the rights of UK citizens. And it's now claimed that the UK has developed a rights-based culture, as all new legislation has to be compliant with the Act. And judges can declare earlier Acts of Parliament as incompatible with the Human Rights Act, and request that Parliament changes them. Parliament doesn't have to. We don't have a codified constitution. The Supreme Court doesn't have that power, but it often will then go and change those statutes. So, in terms of how rights are protected in the UK, we're going to go through this in the rest of the lesson. But as it doesn't have a codified constitution, they're not protected by an entrenched Bill of Rights like the US. The Human Rights Act isn't entrenched. It nonetheless does kind of really help to protect rights in the UK, though. Instead, they're protected by parliamentary legislation, such as the Human Rights Act and the Equality Act, pressure groups, the House of Lords, parties and other groups in Parliament, and common law, among some other things, of course. So, now moving on to the key milestones in the development of rights in the UK. The first one was in 1215, and that's the Magna Carta, which you've probably heard about before. And it's regarded as the oldest statement of rights in the UK, and its original purpose was to limit royal power due to King John being tyrannical. And it's kind of really widely hailed as the foundation of the rights of the citizen, and is regarded as establishing the right to trial by jury. Obviously, at this point, you really didn't have a big set of human rights, but that's the real start. From then on, a couple of decades later, you have the Bill of Rights, which came out at the time of the Glorious Revolution, and that was Parliament further restricting the power of the monarch and increasing its power. From there, this is when rights really began to be very well protected in the UK, and that was with the European Convention of Human Rights, which was drawn up following World War II, and obviously the mass atrocities and human rights violations that happened during World War II. And it was drawn up by the Council of Europe, with the UK as one of its signatories. Effectively, the European Court of Human Rights was set up in Strasbourg to hear cases where people felt their rights had been infringed upon in their own country. So UK citizens could go to that court, appeal to that court, but it was really time-consuming and expensive, because obviously it's in Strasbourg, so you effectively had to be rich in order for those rights to be very well protected, or you needed the backing of a civil society organisation like a pressure group. This was why the Human Rights Act was introduced in 1998. Effectively, what it did was codify the, not codify, but make the European Convention of Human Rights, put it into UK law, so that those rights could now be protected and appealed to in UK courts. So it was passed by New Labour in 1998, and it includes the right to life, right to a fair trial, right to privacy and family life, prohibition of torture, among lots of other rights. So the Human Rights Act is kind of a really key piece of legislation, a really key factor in the protection of rights in the UK, and there's a lot of debate in relation to its effectiveness. So on the one hand, you have some kind of key arguments for the Human Rights Act being effective. So that starts with kind of the idea that since the Human Rights Act being passed, the UK has developed a rights-based culture, as all new legislation must be compliant with the Act, and judges can declare earlier Acts of Parliament incompatible with it. As I mentioned, they can't legally compel Parliament to change it, though Parliament normally does. For example, is a really good example up there that you can see in relation to this, and that's the A versus Secretary of State for the Home Department under Tony Blair's New Labour, and the response to a lot of terrorism in the early 2000s. And effectively, the Anti-Terrorism, Crime and Security Act of 2001, which was passed in order to try and combat terrorism, was declared incompatible with Articles 5 and 14 of the Human Rights Act by permitting the detention of suspected international terrorists in a way that discriminated on the ground of nationality and immigration status. As a consequence, Parliament then went back and amended that statute, introducing the Prevention of Terrorism Act in 2005 to replace it. So that's kind of one of the key ideas, that it creates a rights-based culture by ensuring that all laws in the UK have to be compliant with the Act. Its defenders also argue that the HRA places public authorities in the UK under an obligation to treat everyone with fairness, equality and dignity, and also makes rights more high profile in the UK by educating citizens about their rights and kind of making them a more significant part of the political system. Whilst of course there's also the contrast to the European Convention on Human Rights where previously you had to go to Strasbourg. Now you can just be protected in UK courts, which can be seen as a real benefit in terms of protecting rights in the UK. In terms of arguments against the Human Rights Act, many critics say that the Human Rights Act stops terror suspects from being deported, and that it therefore favours undeserving individuals rather than protecting the legitimate freedoms of UK citizens and protecting society as a whole. So if you look up there, you'll see the example of Abu Qatada to kind of demonstrate that. Also, more recently, especially in relation to illegal immigration to the UK, you've had a lot of Conservative MPs and people on the right of the political spectrum really arguing against the Human Rights Act and proposing a new British Bill of Rights, which I'll go through later in the lesson. So very similar arguments that the Human Rights Act protects the wrong individuals and is kind of therefore very ineffective, especially in halting UK government policy in relation to deportations, for example. So it's also been criticised for giving unelected judges too much power, for example, in being able to define or declare a law incompatible with the Human Rights Act that arguably gives judges too much power in comparison to elected parliamentarians. And the kind of counterpoint, kind of from the other side, is that the HRA may be used to check other laws, but it's not entrenched and could simply be replaced by a simple act of Parliament. And it's also not binding on Parliament. So that's the argument that it really doesn't protect rights very well, because it's not entrenched at all and could be taken away at any point by the government. So that's the Human Rights Act, definitely the most significant piece of legislation in protecting rights in the UK. There's two more that came after that. So the Freedom of Information Act made it easier for opposition MPs, journalists and voters to ask for information about the government. So it effectively made the government a bit more transparent. There are debates in relation to its benefits and drawbacks, which I'll go through in another lesson in relation to Labour's constitutional reforms in part of the UK government topic. But it has been quite successful in, for example, exposing the MP's expenses scandal in 2009. It was quite significant in, and also being used by journalists to hold the government to account quite effectively. Then the final piece of legislation that kind of protects rights in the UK is the 2010 Equality Act, which was introduced by Brown's government. So it brought together earlier pieces of legislation that had sought to outlaw discrimination and unfair treatment, and identified 9 protected characteristics and made it illegal for public bodies, employers and service providers to discriminate against people on these grounds in the workplace or in wider society. So their age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. So kind of, and I think it was on the basis of this that hate crimes were created or the hate crimes were able to be prosecuted. So it's really kind of protecting characteristics and minorities in a lot of cases against discrimination. So it can be really seen as quite key in protecting the rights of individuals in the UK. So that's the key milestones in the development of rights. I'm now going to go on to civil liberties pressure groups. So it says in the specification that you need to know 2 of these. I'm going to go through 4 because it gives you a lot of different examples that you can use, and you can kind of pick the ones you want to memorize for the exam and use in your essays. So the first one is Stonewall. They're a charity and pressure group in the UK that campaigns for LGBT rights. formed in 1989 in opposition to Section 28 of the Local Government Act, which was introduced by Thatcher's government and prohibited the promotion of homosexuality by local authorities. An extremely discriminatory law against LGBT people in the UK, and actually quite reminiscent of current very homophobic laws in Russia that talk about kind of homophobic propaganda. So when Labour came into power, it became an insider pressure group, though. So it started as an outsider, obviously in opposition to the Conservative government, who had introduced discriminatory laws. When New Labour came into power, it took on more of an insider pressure group role, and used its insider contacts and favour to play a key role in policy development, whilst also using some outsider tactics in the European Court of Human Rights to challenge existing legislation. And they had significant success because of that. So, for example, they challenged the banning of homosexuality in the armed forces, which was lifted by the government in 2000 after a successful case in the European Court of Human Rights. And they were also involved in lots of legislative achievements where they played a key role in policy development, such as equalising the age of consent to 16 years old, even though that had to kind of be pushed over the House of Lords' veto. So the House of Lords tried to veto it, but obviously with the Parliament's Acts, the House of Lords can only veto for 1 year. So effectively that was weighted. It was weighted 1 year, and then the New Labour government overrode it, and it was passed. And another key success was the introduction of civil partnerships in 2004. In April 2022, Stonewall, among other LGBT charities, boycotted the Conservative government's first global LGBT conference over its decision to exclude trans people from a ban on conversion therapy, which has actually now been reversed. But that shows how when the government changes, it can change, and government policy changes, pressure groups can really shift from being insider to outsider pressure groups. So that was where it really kind of played a more role, used tactics more in terms of publicity, and became more of an outsider pressure group. The next pressure group I'm going to look at is Care for Calais. So Care for Calais is a charity that delivers aid to refugees in Calais and other areas affected by the European migrant crisis, and campaigns for the rights of refugees in the UK. The group has been part of lots of other groups and individuals that have been fighting legal challenges on behalf of migrants in the UK, threatened with deportation to Rwanda following a deal between the UK and Rwandan governments. So Care for Calais and others, kind of their lawyers, argue that it's unsafe to send people to Rwanda and that it violates the Human Rights Act due to factors such as discriminatory access to asylum for different groups in Rwanda, especially LGBT people. So along with other human rights campaigners, it's had notable successes. So the key success was on the 14th of June when the first planned deportation flight to Rwanda was supposed to take off, and it was kind of emptied one by one until it was completely emptied due to successful human rights challenges. So different courts have judged very differently in relation to the legality of the deal between the UK and the Rwandan government and consequent deportations. But it was a legal challenge in the European Court of Human Rights, which is higher than any court in the UK, that was ultimately crucial. And that was based on the argument that asylum seekers transferred to Rwanda will not have access to fair and efficient procedures for the determination of refugee status. So with that legal challenge, they were able to protect the rights of citizens, kind of showing a real success of that pressure group. Two more I'm going to go through are Liberty and the Howard League for Penal Reform. So Liberty is a pressure group in the UK, a very high-profile pressure group that campaigns to protect civil liberties and human rights. So general kind of remit of protecting democracy, human rights in the UK. They do so through the courts, parliament, and wider campaigns to gain public support and aim to engender a rights-based culture within British society. In the last 5 years, it's largely focused on challenging the Investigatory Powers Act of 2016, which was quite key in expanding electronic surveillance powers of the UK government and police intelligence services. So they were successful in challenging key provisions of the Act, when in April 2018, the High Court ruled that key provisions violated EU law, and that forced the government to amend the legislation. The final group is the Howard League for Penal Reform, which advocates for the rights of prisoners in the UK. In contrast to these other groups, it's had less success, largely because there's kind of less public support for the rights of prisoners in the UK, because they're not really a popular cause. For example, they've been unsuccessful in convincing the government to grant prisoners the vote. They have been successful on some minor issues, though. For example, the 2014 High Court ruling, which obliged the government to drop its ban on prisoners' families sending them books. So that's the civil liberties pressure groups. As I said, you don't need to know all of them really well. I've just given you 4 so that you can kind of pick out examples from there that you're going to remember the best, that kind of appeal to you the most, so that you can remember them and have a good number of detailed examples during your exam for essays in the exam. Okay, so that was civil liberties pressure groups. The next group I'm going to look at in terms of protecting rights of citizens in the UK is the judiciary. So that's first with judicial review. So what is judicial review? Judicial review is a type of court proceeding in which a judge reviews the lawfulness of a decision or action made by a public body and can declare it ultra vires, which means beyond the law, so against the law. And you're going to go into this in a lot more detail in the Supreme Court topic, of which I'll also have a video on, hopefully before the exams this year. This can be in relation to a number of things. So it can be in relation to the authority given to them within existing laws, or it can be checking whether a law or action is in line with the Human Rights Act. It can be overstated its importance, right? Because most applications concern local authorities and only 10% against the government managed to win. Arguments for judicial review argue that it's a vital means of defending citizens' rights, enabling the legality of government actions to be scrutinised, and pressure groups often fund and instigate legal challenges on behalf of individuals, so that it's not just kind of rich individuals who can protect their rights in the UK. In terms of counterpoints, critics argue it places too much power in the hands of unelected and unaccountable judges who are able to effectively make law through how they interpret certain laws. And of course, this kind of unelected and unaccountable nature is furthered by the fact that the judiciary is extremely unrepresentative of the population. So if you look up there's an example of judicial review in relation to the Human Rights Act, or you can download the PDF by going to the first link in the description. I'm going to skip that and go on to Parliament/government. Feel free to let me know in the comments below if you've got any questions about that example. So, how does Parliament and the government defend rights in the UK? The key way that Parliament and the government defends rights is through introducing legislation that protects or furthers the rights of citizens. So that's the ones we went through, right? The Human Rights Act, Equality Act, Freedom of Information Act especially. So for example, the 2010 Equality Act was introduced by Gordon Brown's government. David Cameron's government legalised same-sex marriage, despite it not being mentioned in the 2010 Conservative Manifesto. The UK government also legalised same-sex marriage in Northern Ireland in January 2020 under a period of direct rule when the Northern Irish Parliament and government wasn't in session. Parliament can also prevent the government from encroaching on human rights by voting down bills. So that's especially true when the government is a bit weaker, and especially true of the House of Lords, where the government doesn't have a majority due to the number of crossbenchers. So the House of Lords in particular has often been crucial in the protection of human rights, particularly in the early 2000s, when Blair's government, in response to terrorism, was introducing laws that were kind of aimed to protect collective rights, but in doing so infringed upon individual rights. And the House of Lords was quite key in preventing the extremity of some of that legislation. On the other hand, Parliament and the government can be argued to often contravene human rights in the UK, especially recent governments. I'm going to go through a couple of examples about that now, which have strong stances on law and order and anti-terrorism. So one of the key examples of that is the Police, Crime, Sentencing and Courts Act of 2022, which you might know from there were a lot of protests in relation to it under the slogan "Kill the Bill." So the Police, Crime, Sentencing and Courts Act was introduced in April 2022 and gives more powers to the police and criminal justice system to impose restrictions on unacceptable protests, among other things. So it gives the Home Secretary significant powers to decide the type of protest deemed acceptable and unacceptable by the state. For example, it can limit protests based on them being in the buffer zone of Parliament, which is the size of that was increased under this legislation, being too loud. And it can be seen as, in large part, a response to direct action campaigns by pressure groups and social movements in the UK, such as Extinction Rebellion, and the very significant protests in the Black Lives Matter movement in the summer of 2020. It's an extremely controversial law that was widely criticised by human rights groups such as the ones we went through of these pressure groups, especially Liberty, as well as politicians and journalists, who argued it significantly impeded freedom of speech and the right to protest in the UK. Another example of the government and Parliament being a threat to human rights in the UK is proposed changes to the Human Rights Act by the Conservative government. So, as I mentioned earlier, at various points in the Conservative Party's history since the introduction of the Human Rights Act, it's backed replacing the Human Rights Act with a British Bill of Rights, which has been criticised by hundreds of human rights groups for effectively seeking to remove rights in the UK. So the proposed Bill of Rights would make it easier to deport foreign criminals by elevating public safety over the right to family life. It would also increase freedom of the press by elevating the right to freedom of expression over the right to privacy. So it's really been a pet project of Dominic Raab, and he argues that the Human Rights Act has led to lots of unjustifiably successful human rights claims in court, especially in relation to the deportation of foreign criminals and immigrants. And the Conservative government effectively wants to prevent those legal challenges being successful so that they can deport individuals when they want to effectively. So, as I mentioned, really backed by Dominic Raab, who was and the plan was backed under Boris Johnson's government, shelved by Liz Truss. Obviously, Liz Truss was only there for around 40 or 50 days. So then Raab, who is now, by the time you're watching this video, he might not be, he's now currently Justice Secretary under Rishi Sunak, and it's unclear whether it's going to be back on the agenda. But it's generally agreed that it's quite a threat to human rights in the UK. So the final thing I'm going to go through is key debates over rights in the UK. So this sums up a lot of the content we've gone through so far and really brings in a lot of key analysis points that you can use in your essays. So the first point is a key debate between collective and individual rights, and the idea that collective and individual rights can be seen to conflict. So that's especially in relation to public safety and security, where the protection of the population is used to justify the encroachment of human rights of individuals. Two key examples of this are terrorism and COVID. So in terms of terrorism, Blair's government clashed a lot with the House of Lords following terrorist attacks in the early 2000s. These terrorist attacks led to government measures that limited civil liberties in the interest of protecting the wider community. For example, that was the indefinite or the attempt at detaining suspects of terrorism for longer without being charged, as well as control orders. Ministers argued they had the right to detain terror suspects without trial on the grounds that a national emergency existed. In December 2004, the Law Lords ruled that the indefinite detention of foreign nationals on suspicion of terrorist charges were discriminatory. And as a consequence of this, the government passed a law to introduce a system of control orders that enabled suspects to be closely monitored through electronic tagging and a requirement to report to the police and the removal of phones and internet access. Despite adverse rulings from judges, control orders were kept in place until 2011, when the coalition government replaced them with a modified version and updated them. So that shows how individual rights have been effectively contravened in order or under the guise of protecting collective rights. A lot of human rights pressure groups would argue that it's discriminatory and very dangerous. But obviously the Conservative government and significant sections of the population argue for it. So how does and has counterterrorism clashed with individual rights? There's not been an unremitting erosion of human rights due to counterterrorism, but there have been some restrictive measures, like those ones I just mentioned. And the government have tended to place the safety of society above the protection of individual rights. For example, in 2013, the human rights group Liberty had very little success in deflecting government policy. So they failed to stop the introduction of so-called secret courts used for major criminals and terrorist suspects, where evidence against them doesn't need to be disclosed in full, and nor did they arrest the passage of the Investigatory Powers Bill, which I mentioned earlier, which increased the power of the intelligence agencies by obligating internet companies to store info about customers' browsing history. So electronic surveillance being a key issue there. So that's terrorism. Another key area where individual and collective rights can be seen to conflict is COVID. So the COVID-19 pandemic showed how Parliament can remove the rights of the population very quickly, with freedom of movement and organisation being seriously restricted during lockdowns in order to prevent the spread of the virus. And there are fears that lockdown set a precedent of the erosion of individual rights in order to protect the wider community, and that could be repeated. So, finally, just going to look up and sum up some of the key arguments in relation to how well rights are protected in the UK. A lot of these I've already gone through, but there are a couple of more as well. So in terms of the arguments they're well protected, is that everyone is equal before the law in the UK and has a wide range of rights. The Equality Act ensures everyone is treated fairly and criminalises discrimination. The HRA can be seen as effective. Civil liberties pressure groups can be really seen as effective, as can the House of Lords. And the judiciary can be seen as really important in limiting the government and protecting rights in the UK. Whilst there's also been various extensions of rights in the UK in the past couple of decades, particularly for LGBT individuals. In terms of arguments that rights aren't well protected in the UK, or arguments that they're being eroded, COVID and counter-terrorism measures show how they can be eroded in favour of protecting the collective. Recent Conservative governments have introduced legislation that contravenes human rights, especially the Policing Crime, Sentencing and Courts Act, which, as I kind of mentioned, really limits the right to protest in the UK, while the planned British Bill of Rights can be seen as very worrying. Judicial review can be argued to give too much power to unaccountable judges, while civil liberties pressure groups are important, but they ultimately don't make the final decision. It's still the government that makes the final decision, and the government can be seen as quite threatening at times to human rights in the UK. The Human Rights Act can also be criticised for being too weak, whilst the judiciary can be seen as biased against certain sections of the population due to its narrow composition. So it's very white, it's very male, it's primarily, almost, very much primarily, almost exclusively in the Supreme Court, but primarily Oxbridge educated and relatively wealthy. So that can be seen as really negative in terms of the reality of judicial neutrality in the UK. And those who can afford legal representation can be argued to have more human rights than others, as they can go to the European Court of Human Rights still, and they can afford effective legal representation. So that's all the content. Just circling back to the possible questions again. So as I mentioned at the start of the video, kind of two key questions I can see being asked. This isn't to say that they're definitely all the questions that can be asked, but the kind of key debates are how well are rights protected in the UK. So I definitely practice that essay plan. In terms of that, there's a lot of different ways you could order it. You could do that one in terms of groups. So you could look at Parliament and legislation, including the Human Rights Act as one paragraph, with kind of for and against within that. You could then look at the judiciary, or you can include the Human Rights Act in the judiciary, actually. You can include pressure groups as one paragraph. You can include Parliament/the government as one paragraph. So you can do it in terms of groups, selecting 3 of them. What you could also do is in terms of key debates. So you could have collective versus individual rights as one paragraph. You could have the Human Rights Act and how well that protects rights in the UK as another paragraph. And then you could have how well different groups protect it as a third paragraph, in which you could maybe contrast pressure groups against Parliament and the government potentially. For these essay questions, I'm going to create plans which are going to be as part of the UK Politics essay plans package on the Politics Explained website. They won't be out yet, but they will be before the exam. They'll be updated before your final exam this year. So if you don't want to make them yourself or want some ideas, feel free to purchase them, which will be quite useful. And then in terms of the other question, it's on how well different groups protect rights in the UK. So it could be evaluate the argument that civil liberties pressure groups are the most effective protector of rights in the UK. In that, you're probably going to be doing it a good way to do it. I'm not saying this is definitely not the only way you could answer it, but we could do certain groups with for and against. So you could have civil liberties pressure groups as one paragraph, forming quite a big paragraph because it's mentioned in the question. Then you could have Parliament/the government, for and against within that as well. And then the final paragraph you could have on the judiciary, for example. In terms of if you want some help with planning these essays and kind of really preparing for the exam, feel free to sign up for tutoring on the Politics Explained website, where we can really go through this in a lot of detail. And yeah, go to the Politics Explained website. There's a lot of other resources, free and paid, that you can look through to help you in your politics A-level. And as ever, Let me know any questions in the comments below, and make sure to subscribe for future videos. I'm going to try and get through all of the UK politics and UK government content before your final exam this year. So yeah, thank you very much.